action.
Good afternoon. My name is Oliver Westmoreland. I am an IIA registered level 3 immigration advisor. I'm also senior immigration lawyer at GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so that you can continue to watch our extremely interesting videos about UK visa and immigration advice. Now, today's topic is something a bit complicated. We're going to be talking about evidential flexibility in the context, for example, of working visa applications. And we're going to be talking about something else. We're talking about when an application is made to the Home Office or entrance officer, when you or your lawyer requests that the application be considered outside the rules as well as within the rules. Now, this all sounds a bit strange and complicated. It relates to a particular case which came in the Upper Immigration Tribunal. It was called Ganeshmoorthy. Mr. Ganeshmoorthy, as you might well guess, is a Sri Lankan national. He applied to come to the UK on a skilled worker visa. He had been sponsored correctly and properly for a job as a retail manager. He wanted to submit his application. Unfortunately, for one reason or another, he had taken the wrong English language test. It wasn't completely wrong, but it was just very slightly wrong. He'd taken an IELTS exam, but it wasn't quite the right type. And I don't quite understand the sequence of events completely, but when it came to be submitted, I'm pretty sure his lawyers realised that the thing was not right. But there was a big deadline. The skilled worker rules were changing imminently. There wasn't time to correct anything. It just had to go as it was with the incorrect certificate. I'm pretty sure that lawyers knew about this already, because when they prepared the application, that they wrote a cover letter, and it says, if this was to entrance officer, because this is from Sri Lanka outside UK, it said, please consider our application. However, if you're minded to refuse the application, could you please additionally assess the application outside the rules? That sounds funny, but what it means is this. Application is considered within the immigration rules. It might fail. I thought it probably would actually. It might fail. If you are minded to refuse the application, could you consider it again, additionally, outside the immigration rules on purely discretionary principles? And they added something interesting little words there, because the applicant will be providing much needed labour to the UK's economy, which is now in recession. I'm not sure it was actually, which is now in recession. It is entirely in the public interest that he's granted permission to enter the UK. I think they anticipated that they were going to get a refusal. Unfortunately, they were right. You know, as I say, no, wrong certificate, no, sorry, it's refuse. They ignored this request, important legal point, they ignored this request. Mr. Ganeshmoorthy and his lawyers, they went for administrative review, also unsuccessful. Part of the case was this. They said that the decision maker, when they saw that there was a wrong certificate, they should have written and requested the correct certificate under the principles of evidential flexibility. This is a set of rules, or well, rules and policies actually. If an application is not quite perfect, it's got something wrong with it, but that could potentially be easily corrected with a new document. Rules and policies say that the decision maker should or could write to the applicant or their lawyer, ask for the thing that is missing or wrong, ask for a missing document or a new document. They did think about evidential flexibility in the refusal decisions. There were two refusal decisions by this time. There was the visa application refusal and the administrative review application. They sort of thought about it, but not very, very hard. They said, no, we don't have to do it. The rules and policies say we don't have to do it, so the decisions were both correct. Got to the Upper Immigration Tribunal in judicial review. Now, in judicial review, you have to get permission. You can't just do what you want. It's not like an appeal. If you have the right to appeal, you can just appeal. It's a statutory appeal. Judicial review is different. You don't have any right. you've got the potential right, but not an absolute right. You have to get permission from the upper tribunal to proceed with the judicial review action. But judicial review judge said, no, it's has potential merit to it, could be successful. They accepted the application. Well, actually went very successfully for Mr. Ganeshmoorthy. First of all, the judge in the upper tribunal said the visa decision maker should have asked for the extra document because they didn't understand their own rules and policies. Now, interesting fact, in the last couple of years or so, the policies have got more and more generous, broader and more generous, in a points-based system application such as a skilled worker application. The policy says this: the decision maker, if it's something that could easily be rectifiable, the decision maker should normally write to the applicant and request the document that would solve the problem. It could be a missing document. In this case, it was an incorrect document. They normally should write to the applicant or the lawyer, ask for the missing document, but they didn't. Judge says, well, you didn't understand your own policies about that. And similarly, we got to administrative review. Now, Mr. Ganeshmoorthy or his lawyers, very cleverly, they got the correct certificate and they submitted it with the administrative review. So the administrative review decision maker had the correct certificate in front of them when they made this decision. But still, he said, oh, no, sorry, these rules don't apply to you. I'm sorry, the refusal is good. So anyway, that's what happened. It sounds unreasonable. It wasn't just unreasonable. As the court explained, it was unlawful. If the law contains this word normally, you expect it to happen most of the time, don't you? That's what it would mean in normal English or legal English or anywhere. They didn't understand their own published policy. That's an error of law. If the Home Office publishes policy guidance and it makes a clear promise, you're stuck with it. They didn't. So Judge said there were two things wrong. First of all, visa application was wrong, should have asked for the correct certificate. Administrative review refusal was wrong, still should have asked for the correct certificate. So Mr. Ganeshmoorthy had already won his case. However, this other issue came into play. Like I said in the cover letter, the lawyer said, if you're going to refuse the application, please consider it under please reconsider it or additionally consider it under purely discretionary principles because of blah, 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 blah. In the refusal decisions, this was not mentioned at all. It was ignored. That's an error of law as well. There is case law, and this goes back years actually. If the applicant or the lawyer requests consideration outside the rules, the decision maker, at least they have to go through the exercise. They have to say, yes, we considered your request, but we rejected it. That is enough. But they didn't mention it at all whatsoever. They ignored it. This was an error of law as well. Now, here we got into a very sort of complex thing because the lawyer for the Home Office at the court hearing tried to use a special bit of law. They said, well, even if they had done, it wouldn't have made any difference. So that's not really an error of law because even if they had considered it outside the immigration law, it wouldn't have made any difference. The decision would have been the same. Judge didn't like that either. He says, well, how do we know? It's not knowable. And we got into a very complex discussion here. I'm not going to spend all day on it. I'd like to, but with judicial review, the question before the court is not, is it a good decision or a bad decision? The question is, was the decision infected by error? That's the test. It's not saying, is it a decision that I like? Is it a decision that I would have made? It's was the decision affected by error or not? That is the test of judicial review. Upper Tribunal said this, how can we really know if it would have made a difference or not? Because if we're going to be speculating, we would be trying to decide whether a decision was going to be a good decision or not, which is outside the principles. The principles was a decision infected by error. We're talking about a hypothetical decision. We're going to be going outside the rules because we're going to be thinking about, was it a good decision or a bad decision? So I said that doesn't work. He said it a bit longer than I did, but he said that doesn't work. And Mr. Ganeshmoorthy succeeded on the third ground as well. He succeeded on three things. Visa application was wrong. Admin review application was wrong. Refusal to even consider the applicant outside was wrong. So he won all three. So that's a good victory. So these things do know. The rules now about evidential flexibility, not for Appendix FM, but points per systems, working visas, study visas, the rules are, well, actually the policy is very very broad and very generous. If the Home Office doesn't follow that, the Home Office is in the wrong, it's an error of law. Second thing, I mean, this isn't really new, it's just re-establishing what we already knew. If you or your lawyer requests consideration outside those, in a case like this, when you think, oh, maybe the applicant is a bit weak, if you say to the Home Office or entrance officer, if you're going to refuse, please could you then additionally consider it on a purely discretionary basis. If they say, yes, we did, but it fails, fair enough. If they don't say anything, they have made an error of law. Now, Mr. Shah, do you have any questions about all? Yes. Can I read just a couple of things just come to my mind from the summary conclusions? Ground 2. The ECO's original decision was vitiated by her failure to apply the evidential flexibility policy correctly, and that policy was prima facie applicable in circumstances in which there was reason to believe that the applicant could obtain the missing document. Well, we know that they'd already provided it, but the rule had changed to this wording. If a person could obtain a document that's missing, but, well, they could and they did. Interesting thing, these two IELTS certificates, they were at the same level. The difference was just in the form. It was the same level. It was just not quite the right type. Other things, ground 3, it's about the request to consider it outside the rules. The ECO's original decision and the administrative review decision were unlawful for failing to consider whether to grant leave outside the rules, and it is not clear that the same outcome would have been reached if the correct approach had been applied. Please give me your questions, Mr. Shah.
Thank you very much for dwelling into this very interesting case, indeed. And before I ask my question, I just want to add that what we have basically seen a lot of the times from the Home Office, that they do not usually request additional documentation with entry clearance application. They just refuse it if they're not happy with it. But we've seen, on the other hand, with the applications from applicants who are inside the UK, if they're missing something or something is wrong, more likely than not, the Home Office caseworkers reach out to us, ask for whatever they need, and then make a decision. So we see a clear difference.
Well, that's not right. The law is exactly the same for entry clearance or in-country leave to remain application. If that is statistically true, it's not legally right.
True.
But the distinction comes between Appendix FM, where the rules are not so generous, points-based system, they're a lot more generous.
True. Great. And the question I wanted to ask you, you mentioned about evidential flexibility. Is this something that is available for all kinds of UK applications?
Yes.
Okay, fantastic.
But you've got slightly different rules in different cases, but it's available for anything.
Brilliant. And last question, this
it could apply even to visitor visas, quite possibly.
True.
I don't think I've seen many requests for extra diligence with visitor visa applicant, but it certainly could do.
But we haven't received any. No. They just make a decision. And this discretionary part, so this is understandable that it is also applicable to point-based system applications.
The points-based system rules are more generous than the other rules, funnily enough. Working visas, study visas, the rules, well, the policies are more generous.
Fantastic. That's good to know. Well, I thank you for today's vlog.
Thank you for having me.
It's my pleasure, and we see you in the next one.
See you next time. Goodbye.